Rock Advertising in the Court of Appeal. Mr. Darton, who appeared on behalf of MWB, had argued that the judge in the Central London Criminal Court had fallen into error in his approach to consideration. In support of that contention, he relied primarily on two cases, Foulkes and Beers in the House of Lords and Reselect Move in the Court of Appeal. Now, he submitted that the judge was wrong to find that Rock's payment of $3,500 and its agreement to comply with the other terms of the revised schedule payment amounted to good consideration. He argued that the kind of practical benefits put forward in both Foulkes and Beers and Reselect Move, whereby there was agreement to make payments by installments, did not amount to consideration. Mr. Dutton submitted that the rule in Williams and Roffey, if it were to be extended to the circumstances of Foulkes and Beer, that must be done either by the House of Lords as it then was, or the Supreme Court now, or by Parliament. Mr. Justice Kitchen said, referring to Darton's contentions, that Mr. Darton had failed to take proper account of the full extent of the factual findings of the county court judge, who was clearly of the view that the oral variation agreement would have a number of beneficial consequences for MWB. First, MWB would recover some of the arrears immediately and would have some hope of recovering them all in due course. But secondly, and more importantly, Rock would remain as a licensee and continue to occupy the property, with the result that it would not be left standing empty for some time with further loss to MWB. There was no suggestion that MWB was at any material time labouring under any kind of duress. There was, so it seems to me, a commercial advantage to both MWB and Rock in reaching agreement if that could be achieved. Accordingly, this is not a case in which the only benefits conferred on MWB by the oral variation agreement were benefits of the kind contemplated by Lord Blackburn in Foulkes and Beer and by this court in Select Move. MWB derived a practical benefit that went beyond the advantage of receiving prompt part payment and the rest in installments over the revised repayment schedule plan. This is therefore a case where, as in Williams and Roffey, Rock's immediate payment of the $3,500 and the agreement to perform its obligations under the revised payment schedule conferred a practical benefit on MWB which amounted to good consideration, so rendering the oral variation agreement enforceable. Lord Justice McComb agreed with the reasons given by Lord Justice Kitchen and by Lady Justice Arden.